Court TV Live, I'm Julia Janae. Thank you so much for being with us this afternoon and following along where we are in day 4 of deliberations in the Karen Reed trial. And the jury has said to the court that they have been unable to reach a unanimous verdict until this point. Take a listen.
Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. Signed by the foreperson. We all know how hard you've been working. Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. Or continue your deliberations, all right? So I'm sending you back out.
And that is what's happening right now. Those deliberations still going on. The judge sent them back, said that they should enjoy their lunch. We were getting word that the lunch was going to be delivered and that they would not deliberate through their lunch. So that's different from what we've seen throughout this week. But it seems like we are getting close to a potential mistrial. Let's get a live report from our Matt Johnson soon in the next hour. But for now, we're going to get you into the courtroom as soon as there are any developments in that case. In the meantime, though, we want to head back to another case that we are following here on Court TV. It's the case against Karen and Michael Murray. Closing arguments are going on in the brother-sister murder trial. They are accused of neglecting their mother, which prosecutors say ultimately led to the 68-year-old's death. Let's go back in now. We're picking it up where we left off with the prosecution's closing argument in front of this jury.
Sheila couldn't speak to them, and although only one eye was open because the other was so infected it was swollen shut, she would track them. They moved around her with her one eye, showing that she was aware that they were there. Dr. Christy Lawson told you that she had a very clear memory of Sheila Murray. She said that Sheila Murray arrived at the hospital covered in feces and vomit. She said that Sheila was cleaned by medical staff because she was covered in feces, that she had to be, quote, extensively cleaned off of her body before they could fully evaluate her wounds and take photos of her injuries. She described to you the multiple wounds over a large portion of Sheila Murray's body that she observed and that were treated. She told you that that ankle wound was significantly, her words, significantly infected. She told you that the severity of Miss Sheila's condition indicate to her this is not something that happened overnight. This isn't a one-time event. This is a series, a repeat behavior of neglect. She said it was important to her that Miss Sheila was admitted to the hospital because there she could, quote, receive care and be safe. She said, quote, Miss Murray will always be in my memory because of the severity of the neglect and the compassion and emotion that I felt for her. An experienced, seasoned trauma surgeon broke down in tears in talking about what she saw, what she knew that Sheila Murray had endured. Lastly, you heard from Dr. Emily Cook, who told you that the cause of Miss Sheila's death was sepsis due to delayed treatment of the right ankle fracture with a contributory factor of decubitus ulcers, bed sores. She said that the manner of the death is homicide. And she said due to the delay in medical care and the unsanitary conditions the decedent was forced to endure in her home, her fractured right lower leg became unviable. The bones became infected, and this infection ultimately led to her death. This is evidence of neglect. She told you that, like Dr. Lawson, this was a case that was beyond the pale. Had she seen bed sores before? Yep, nothing like this. Had she seen elderly patients come in for autopsy? Yes, nothing like this. Ladies and gentlemen, this is not a case of medical ignorance. We just didn't know what to do with that huge gaping wound in her back. We just didn't know what to do with that bone sticking out of her leg. We just didn't know what to do with that giant patch of yeast under her neck. So, I guess we do nothing. No. Ladies and gentlemen, this is a clear-cut case of willful and knowing neglect. This is a case of the utter lack of care by the very people who should have cared the most. Her own children. Ladies and gentlemen, hold them responsible. Return the verdict that truth dictates. Return the verdict that justice demands. Find them guilty. Find Karen Murray guilty of the murder of her mother, the neglect of her murder. Find Michael Murray guilty of the murder of his mother, the neglect of his murder, because the evidence shows you that's exactly what they are.
Thank you, Mr. Wallace. Break. Everybody needs a break. All right. Your lunch should be here in about 35.
A fiery closing argument from the prosecution in this case. They are taking that break. Let's bring in an in-studio guest we have. Criminal defense attorney Jeffrey Wolf is here. Jeffrey, you have experience with seeing some neglect cases where it's either in a nursing home or at home. Were those criminal or civil? And where's the line between civil liability and criminal liability in a case like this?
All of the cases I deal with are criminal. So everything I've seen is in the criminal context. The line is typically whether the state is actually getting involved or whether it's families fighting. That's typically where the line becomes. These cases can turn on a dime, is what I've seen. The line tends to be how quickly and how bad the injuries get before somebody gets help. And in this case, obviously, no help came. It was death. And so when that happens, you're going to see the state get angry. I've seen it a million times. Prosecutors hoot, holler, kick, and they get so mad about these cases. But the care that is neglected in cases like this is often not done on purpose. It's often lack of training, especially in a home like this. We see it in nursing homes all the time, where there are people working in these homes who don't quite know what they're getting into. But we can definitely see it when we have home care, where we have children taking care of their parents, and like the defense is positing in this case, they are just in over their heads. They are not qualified to be taking care of somebody who needs the level of care that these people's mother needed. And so it happens all the time, unfortunately, and it's quite tragic.
Really unfortunate to know that, to know about the crisis of people needing the resources, needing more help inside of these homes, and sometimes it's not until the worst happens that you then have so many people with eyes on the case. Let's talk about these defendants. They're sitting there inside of the courtroom. It's hard to really take in how they look, because Michael Murray, the entire time, he's fidgeting, he's playing with his hair. Karen Murray has been very emotional throughout. It almost doesn't matter who's on the stand. When something is mentioned about her mother, we're seeing her crying or wiping away tears. And perhaps that's speaking volumes to the jury. We'll see what happens when the closing arguments start from these attorneys. Your thoughts on how you pose a defense? What should be your theme when you are talking to this jury saying, don't give them a conviction?
Well, you're looking at two people in their 40s who have not led the normal course of life, right? These are people who still lived at home with their parents, taking care of their elderly mother, and obviously in over their heads. No question about it, because they have zero training to do it. But you also want to look at just the normal course of their life. What leads 40-year-old people to still be living together with their sibling and living together with their parents, there to even have this job of taking care of their elderly mother? How does that happen? And then look at them in the courtroom. One of them has zero emotional stability, zero ability to control the emotions, zero ability to regulate their emotions. The other one is sitting there playing with his hair. We've seen it over and over and over again throughout the trial. And so you want to present that to the jury as, who are these people, and why would we say that they can form the mental status to have harmed their mother in any way, shape, or form on purpose to get to a mental status of murder? And that's what you want to present to a jury is look at who's sitting in front of you, look at how they ended up where they ended up, and look at how they're sitting in front of you today.
Yeah, we'll see how far the defense goes once they get the chance to speak directly to this jury, not just through witnesses or cross-examination. We're going to get to a break, and we'll have the beginning of that defense closing argument on the other side.
Action was just to pull out the revolver, and it went off.
Two people accidentally shot.
Alec Baldwin was the actor on set. Alec Baldwin? Yes, sir.
Hurry, hurry, hurry was the motto on the set.
Right away, let's reload.
Alec Baldwin claims he didn't pull the trigger. Well, the FBI disagrees.
It's not going to fire until you pull the trigger.
They really do have to show that he couldn't care less.
The Case Against Alec Baldwin premieres Sunday, 9/8 Central on Court TV.
back to the brother and sister murder trial happening in Tennessee. The prosecution in that case says that the siblings who are defendants, Karen and Michael Murray, that they are responsible for the abuse and neglect that resulted in the death of their mother, 68-year-old Sheila. This happened back in 2019. And right now, we're about to watch the defense deliver their closing argument for this jury. Michael Murray's attorney is starting first.
Good morning, everyone. How are you all? You know, when we started this trial, we talked about the fact that this is a family thing. I said that in my opening. The family here consisted of Edwin Murray, the father, Sheila, the mother, Michael, Karen, and Sonia. And this was a tightly knit family. They cared about each other. They loved each other. The family was limited as far as financial resources. No doubt about that. That was an issue in this case. When Sheila had a stroke, the family pulled together because they wanted to make sure that she was taken care of. We heard from Sonia when she testified that in the beginning, it was good. In the beginning, it was good. Sonia also said that as far as the caregiving went, there was a hierarchy, okay? What was the hierarchy? The hierarchy was Edwin. And I know you haven't heard his statement, but Edwin, we know from Sonia, is the one who made the decisions. And then it was Michael and it was Karen who did what their father wanted them to do. That is the way it worked. That's the way it works in a lot of families. There is one that leads and others that do what they're supposed to do. Now, we know from Sonia's testimony, the care was good, and we know that Sheila was a strong-willed woman. We also know that she wanted to stay at home. Now, as time progressed, Sheila's health began to decline. And in early 2018, we know that she went to the hospital. And she was there for about a week. And then she went to rehab at Cornerstone. And she was in rehab for approximately 20 days. At the end of that 20 days, a decision had to be made. Is she going to stay in a facility like this, or is she going to go home? Who made the decision? Edwin made the decision. And yes, my client even said that they were worried, Edwin was worried about finances. How would we pay for that? How would we pay for that? The decision was made by Edwin, and Karen and Michael were there to take care of their mother. Now, Agent Pritchard asked my client, what was the routine? What was a routine day like? Now, this is not necessarily at the end, but this is like maybe when she came home from Cornerstone. What was a day like? We would talk to Sheila. We would communicate with her. We would get her up so that she could use the bedside commode. The sheets on the hospital bed were changed several times a day. She was fed and she was given liquids, things to drink. The family never left her alone. There was always someone that was there. Either Edwin, the father, Karen, the daughter, or Michael, the son. We also know from Sonia's testimony that my client has some issues. She, in her opinion, he can't even take care of himself, but he was part of the team, taking care of the mother. They were all doing what they could do. And yes, what he was there to do was some of the heavy lifting. That was his role. He took medications that made him sleep, sometimes until noon. And there, you know, when you talk about what one person can do for someone when they don't have any help until maybe midday, that makes things difficult. No doubt about it. It makes things difficult. But the family never left her alone. Miss Romans was a nurse practitioner that would visit approximately every 90 days. And she surveyed the situation. She monitored Sheila's health. She did those tests that was talked about. And she never saw anything that would cause her to want to or required to contact the Adult Protective Services from what she saw. During the time that Miss Romans was visiting, there was the one canceled appointment. And why was that canceled? Karen was not feeling well that day. We know from Miss Romans' testimony that she never spoke to Michael about Sheila, and she never contacted the spouse about Sheila. She never got in touch with Edwin. Sonia has testified, when we talk about this missed appointment, Sonia has testified she met with her mother in February, and she met in July of 2019. She saw her mother, and she stated she did not see anything out of the ordinary. Sonia felt, however, that her mother did not recognize her. Her mother was declining, no doubt about it. But she also said that the family was taking care of Sheila as best they could.
The defense attorney there for Michael Murray saying his client couldn't even take care of himself, according to the other sister that was not there inside of the home where Sheila was living. We're going to squeeze in a break and get you back in for more of the closing arguments in the case against Karen and Michael Murray. stuck or are they moving along? The jury in the Karen Reed trial has been deliberating now for 19 hours and 15 minutes. That's in the killer or cover-up murder trial. They told the judge earlier today that they had not been able at this point to reach a decision. We didn't hear them say the words that they were deadlocked. Hopelessly deadlocked is what lawyers know are the magic words if the judge hears that. She has to give a specific instruction if she wants them to go back in and keep deliberating. The judge did instruct this jury to go back in, keep trying, clear their mind, and work towards a verdict. Karen Reed faces life in prison if she's found guilty in the 2022 death of her Boston police officer boyfriend, John O'Keefe. We'll take you into that courtroom live as soon as there's a verdict or if the jury has another question today. We don't want to miss that. In the meantime, though, let's head back to Tennessee for the brother and sister murder trial. 68-year-old Sheila Murray was hospitalized on August 10th, 2019 after paramedics found her covered in bed sores and with a bone sticking out of her leg. Murray died from complications at the hospital, but the horrific state that she was in led investigators to start digging in and ultimately the arrest of her two children, Michael and Karen Murray. Both are charged with first-degree murder. And right now we are listening to a defense closing argument. Michael Murray's attorney is the one delivering right now. Let's go in.
Of all of these witnesses, just like you all have listened to all of these witnesses, and I have to tell you, in the jury instructions that we received this morning, there are three types of crimes. There's knowingly crimes, there's recklessly crimes, and there's a crime of negligence. I have to tell you, in looking at the legal definitions that you have in those jury instructions, please pay attention to them, because I think you'll find that with the testimony that we've heard, the proper verdict in this case is not guilty. Not guilty of all offenses. Thank you very much.
Mr. Byrd, we haven't got word yet that lunch is here. You want to get started? I hate to interrupt you during closing or any other attorney, but they're not here yet. No. All right, they're not here yet.
That's fine. I don't know if we have any idea about how close they were.
I don't. They're supposed to be, but sometimes it's a little behind.
Okay, that's fine. You can start and pick up later. That's okay. All right. Folks, first thing I want to do, cases like this are never easy for anyone. And I want to thank you for your time and your attention on this. There's never a case like this, no matter what angle you look at it from, that's easy for anyone to deal with. And certainly, I know it's appreciated by all of us that you all came in here, did your civic duty, sat through all this, gave us your time and attention. So I just want to let you know that's very much appreciated. What Karen Murray and Michael Murray are guilty of is being poor. Being poor in a country where at some point it became normal for families to have to do the kind of calculations that the Murrays had to do. That when it came time that somebody got sick, somebody got old, whenever that showed up at your door and you had to figure out what to do, that it became normal for families to have to scramble to figure out what to do and how they were going to get adequate health care. It became normal for people to have to worry about losing everything that they had, losing their homes, losing, what little bit that they tried to scratch out their whole lives just because somebody had the gall to get sick and get old. At some point, that became normal. Don't know why, don't know who to blame for it, and I wish it weren't that way, but that's the way things are, and that's the situation that the Murrays found themselves in. The reality of it is that people like Sheila Murray, people like Tony Murray should have never had to worry about finances, never had to worry about what they were going to do as they got older in terms of being able to have adequate health care. Tony Tony Murray served his country in the Navy and then his community with the Johnson City Police Department. So he wore a uniform for 36 years in service to his community. And his wife of 46 years, Sheila, was even more important because she was a bedrock for a family. She was a foundation for her husband, for 3 children. And they should have never had to worry about being in a position where they have to put their children in a place where their children are going to have to care for them. Their children who don't have the qualifications to do this, with the limited finances, a limited resource, with their children not having the knowledge, the experience to have to take care of their parents as they got up in years, as they declined. But far too many people find themselves in a similar situation. This family should have never been put in a position where it would end up with Tony Murray sitting on the front steps of the family home, sobbing uncontrollably and telling first responders that he was doing the best, that they were doing the best they could with what they had, as his wife is being taken away in an ambulance. And the depths of how far over their heads this family was being demonstrated to him. It's not really surprising that Tony Murray would pass away so soon after his wife, that he passed away 3 months after she did. Between his own health problems and between the grief of, which not hard to imagine that losing your spouse of 46 years would cause a person a tremendous amount of grief. So it's not really surprising that Tony Murray would have passed that soon after his wife. But make no mistake, Tony Murray, if he had lived, would be sitting over there with his children right now. And a very high probability that he would have been charged with this too. But he passed away and he wasn't. So Karen Murray and Michael Murray, what they are not guilty of is knowingly neglecting their mother. What they're not guilty of is murder, not in the first degree, not in the second degree, not in any degree. Dr. Cook talked about the cause of death being homicide. I want to make sure you're clear about what homicide means. Homicide, the basic definition of it is the death of one person by the actions of another. Now, that doesn't mean that it's intentional. It doesn't mean it's knowing. It doesn't mean necessarily that it's reckless or that it's negligent. Homicide can entail all the way down to something accidental. So know that that's when you see the cause of death being homicide, that doesn't mean that there's intentional action. That doesn't mean that there's knowing action. That's the reason you got all those lesser included offenses that we went through earlier. For example, they all have different definitions of responsibility. Things like criminally negligent homicide, which doesn't even allege intentional or knowing conduct, just that negligence happened. Dr. Cook testified about how the sepsis from broken ankle was the cause of death. And a lot of talk has been at this podium about, what the family knew about this injury, what they didn't know.
Both of these defense attorneys have spent some time talking about the father, Edwin Tony Murray, of these 2 children, adult children. Let's bring back in criminal defense attorney Jeffrey Wolf, who's here in studio. Jeffrey, your thoughts on Bill Donaldson, who represents Michael Murray, and Chris Bird, who represents Karen, their presentation to the jury, because it's different.
Yeah, Chris Bird is blowing the other attorney away. This is an extremely more effective presentation. What he's doing is he's grounding his close in humanity. And that's what we were talking about before, is you have to present the life of these defendants to the jury. You have to present humanity to a jury in a case like this. It can't just be another closing argument when you're talking about the death of somebody's mother in such a horrific fashion, in a way that somebody is going to hear it and is going to be so horrified by the prosecution in the way that that DA stomped her feet and pointed her finger. You have to give the jury some humanity to look at, and that is what Chris Bird is doing here in his summation. He's saying they are guilty of being poor. He's saying that this is something that is wrong with America, that this woman died because her children and her husband were too poor to take care of her, that her husband gave his entire life to service, and that she shouldn't have died because her family was too poor to put her in a home that knew how to take care of her. that is extremely effective. That is something that the jury is going to be able to go back into the jury room and talk about. And it is a great storytelling technique.
And I don't think it's uncommon for these jurors to no doubt have people that they know who have been faced with a similar difficult decision of whether to care for a loved one in the home or to find outside help, and to struggle financially with being able to do that. These cases were not severed. You have both the brother and sister sitting here next to each other, but there could have been a situation, right, where Michael Murray could have pointed the finger at Karen Murray if, as his defense said, he can't even take care of himself. He would have been very low on the hierarchy inside of this family.
Yeah, absolutely. And it's one of the reasons that it makes it so hard to try a case when they're not severed, is because you have basically a jury presented with a unified front on the defense, where you have two defendants sitting at the same table with their lawyers sitting there, having to present in a way that doesn't annoy the jury and make it look like they're delaying the case and they're making it take longer by asking separate questions and giving separate closing arguments and separate opening statements and separate jury selection, and just doubling up the time of the trial as a result. But at the same time, you still have to put on your own defense, and sometimes that means pointing the finger at your co-defendant, which is why they have separate attorneys. And so it creates a lot of conundrums for co-defendant attorneys in these cases, and it's one of the reasons that I think it's really hard to ever get a fair trial when you have to sit at the exact same table as your co-defendant and be tried at the exact same time.
Yeah, certainly the resources is likely why the court and the prosecution wanted to do these at the same time if possible. But we are going to see how the closing argument plays out. Chris Bird, they're taking these jurors inside of that home. Don't go anywhere. We are going to pick it up right where we left off, and we are keeping our eye on that Karen Reed courtroom, where 19 hours and 27 minutes have gone by, 4 days of deliberation. No word yet since that note earlier today where they said we have been unable to reach a verdict. Stay with us.
Friday nights, the WNBA is on Ion. Tonight, Ryan has a dream of blocking out Dejanay in the sun. Then, can Lexi and the Sparks rise above Diana and the Mercury? Coverage starts tonight at 7. Ion, it's on.
Tonight on Closing Arguments, a fourth day of deliberations in the case against Karen Reed. We'll dive deeper into what this jury may be wrestling with as we await their decision.
Closing Arguments, tonight at 8, 7 Central, only on Court TV.
Hey.
Before we get you back into that courtroom in Tennessee, we have a quick update out of New Mexico, where we are expecting to find out whether a judge is going to throw out the involuntary manslaughter case against actor Alec Baldwin. Now, his legal team has filed their motion to dismiss, and they argued that the gun used on the shooting set of the movie Rust was destroyed during testing by various officials. The case against him, they say, because that gun was destroyed, should not move forward. Now, if his trial does proceed, the big question is whether he's responsible for firing a weapon during that rehearsal that killed the cinematographer Helena Hutchins.
It's not the actor's job to ensure the safety of the set. It's the first AD's job, like I said, and it's the armorer's job to specifically ensure that the weapons are safe, and that the actor has a million things going on in their head where you're expecting them to show up on camera and give emotions and to stand here and to hit your line and to not cast your shadow on the other actor and now cry.
We're not asking you to be an armor, not asking you to be an expert in firearms, just asking you to be safe and use common sense. My God, if you can't remember your lines and you can't remember to make sure that the gun is empty, then you shouldn't be an actor, you shouldn't be on camera. If that scene were him in the church and he was going to commit suicide, I guarantee you he would make sure the gun was totally empty before he rehearsed that scene. He would not just blindly take that, pull the trigger, he wouldn't. He would make sure that the gun was empty. Because why? His life depended on it. But yet he didn't extend that courtesy to anybody else.
This Sunday, you can catch Court TV's latest special report, the case against Alec Baldwin, at 9 p.m. Eastern, right here on your front row seat to justice. Let's get you back to Tennessee now, where Michael and Karen Murray are accused of neglecting their bedridden mother, Sheila. Prosecutors say it ultimately led to the 68-year-old's death. And right now, we are hearing the closing argument from Karen Murray's attorney, Chris Bird. Let's go back in right where we left off.
They discovered it before first responders were called. The family was asked about what happened to this ankle, and they offered a variety of possibilities of this that they didn't know. They said, she had this history of falls. Something could have happened when we were moving her to the commode at some point. We don't know. We've not heard anything to dispute that they knew what was happening, that they were covering it up. We've not heard anything that disputes that during the course of these days we've been here and this testimony that we've heard. One of the problems was that Sheila's declining condition, and you heard a lot about that she had been rendered nonverbal, that she was, Dr. Lawson testified about the assessment that was done on her whenever she came in intake, and that she was just one grade above what they would look for in cases of people with traumatic brain injuries or people that are comatose. She wasn't to that, but on the numbers, she was one grade away from that. So it's clear that by this point, she's severely mentally impaired, that her ability to communicate is virtually non-existent. This isn't the case of an able-bodied person that breaks an ankle or sprains an ankle, gets any kind of injury, and that can communicate in some way, I'm hurt, hey, something's wrong with this, let's look at this. The unfortunate thing about this is that Sheila had progressed to a point where she couldn't communicate that way anymore. You heard Sonia Henry talk about the condition of her mother's foot, the lipedema. Same thing that you heard Karen talk about. You heard both of them during the course of this. Sonia from the witness stand and Karen with her testimony or her interview with Agent Pritchard. You heard both of them talk about that this was a condition that she'd had for a long time that caused her foot to turn at an angle. But that's the way her foot was generally, and that's what they knew. I mean, you heard Sonia and Karen both talk about that. And that she had a condition where she would swell. She had edema, that her ankles would swell. That she would wear dark socks, I think, in order to help control the swelling that she would have. They didn't realize that anything was different about her ankle. They didn't realize that this bone had worked through the skin until they unwrapped it that day and realized what they were looking at before 911 was called. And I want to clear up something here because the state mischaracterized this in its first open because this was something that came from the witness stand. It's been implied throughout this that either Karen or Michael is the person who called 911. And that's not what happened. As Agent Pritchard told you from that witness stand that Tony Murray called. It wasn't one of them. Tony Murray called. Now, why dispatch made the decision to characterize this as a non-emergent call or something that they didn't need to cut their lights on, I couldn't tell you. We haven't heard that. Is it possible Tony was in shock? I don't know. But I find it hard to believe that the same Tony Murray who, when first responders got there, was sobbing uncontrollably to the point where they felt like they were going to have to give him medical attention, was somehow nonchalant in calling for help for his wife and her injuries. I have a hard time believing that he was nonchalant, that he didn't appreciate the seriousness of it. So I want to clear up that characterization of this call to 911. State talked about Michael Murray saying that his mother had complained about her foot hurting. And I have to point out that you've repeatedly heard that by this point in time that Sheila Murray was nonverbal. So how could she say that her foot was hurting if she was nonverbal? You heard some testimony, you heard some evidence regarding Michael Murray and some of the mental health issues that he had. I don't know if it played into it or anything, but if you notice in his interview with Agent Pritchard, sometimes it seemed like the two of them were having two different conversations. The Agent Pritchard seemed to constantly have to guide Michael back to what he was trying to ask. And I submit that may have been another case of that, because what has been attributed to Michael as his mother saying that her foot hurt was something that we know from the evidence wasn't possible by that point. And that she didn't spontaneously heal and just suddenly regain the ability to speak and then it go away again. By this point, she couldn't talk anymore. Speaking of Agent Pritchard's interview, he told you the family came in freely and voluntarily, that nobody forced them to come in, they weren't drug in handcuffs, that they were asked to come in to talk about this, and that's what they did. They came in, and as you heard him tell you repeatedly, when asked about things that they said, he said he didn't have any reason to believe that they were being untruthful with him. You know, and I'd remind you that they're being questioned about this roughly 2 weeks after their mother has passed away. And you hear what an important person that Sheila Murray is in their lives, and anybody that's gone through a loss like that can tell you the effect that grief has on a person, especially in those first days, those first weeks. The effect it can have on your ability to remember things, just your emotional state in general. Memory can be different for two people trying to recall the same event. State talked about it in jury selection. They pointed out that about going through and talking about what if two people see things a different way. You saw it to some degree here in this trial, because if you caught it, what paramedic Jenkins and EMT Shelton, how they recalled their encounter with Mrs. Murray, there were some differences in how they remembered it. Not because they were trying to be untruthful, but because memory does that. Two people can see the same event and can remember things different ways. Their recollection, if you heard what they said, their recollection of when Mrs. Murray responded with pain was different. It wasn't the same. That didn't match up. Does that mean that they're lying? Does that mean that they're coming up here and trying to mislead you? No. It just means that memory can be misleading. We talked about in the beginning about this, about the importance, taking notes, about a short pencil beats a long memory. And that's why, because memory is fallible. Sheila Murray, you heard a great deal about her advancing dementia, the effects of multiple strokes. As I said earlier, it's clear that she was very impaired by this point. And that's not her fault. Nobody asked for that. Nobody asked for that sort of thing to happen to them. But that's the condition that she was in. And her decline was gradual. That it went from the time she went into Cornerstone, when the family realized something severe had happened, something drastic had happened, and quickly took action when they realized it. She goes to Cornerstone, she gets out, she comes home, and then it's a slow decline. And you can see it in those records that Tracy Romans produced. You can see it. From what Sonia Henry talked about with her mother, this slow decline. You're watching this.
All right, we're hitting the pause button on this closing argument by the defense, and we're also going to get an update on the other side of this break from Matt Johnson, who's on the ground in Dedham, Massachusetts. He's been speaking to supporters and those in opposition against Karen Read outside of the courthouse. Stay with us. This is Court TV Live.
will help kids just like me have the best part of our day.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, of course, honored to be with you. We are following big developments in Dedham, Massachusetts in the murder trial of Karen Reed. The jury is saying we are deadlocked, but the judge has instructed them to keep going, keep deliberating. Could we be moments away from a mistrial? The day is winding down, and we should be getting an update soon. Joining us now live with all the latest is our own Court TV crime and justice correspondent, Matt Johnson, standing by outside of the courthouse. Matt, always great to be on with you. Tell us, what is the latest with these jury deliberations?
We are on pins and needles outside the Dedham courthouse, where this trial has been unfolding for 11 weeks, if you include the 2 weeks of jury selection. So these jurors have been vested in this process since that time. Today, indicating that they could be deadlocked after nearly 4 days of deliberations in the courthouse here behind me, sending a note to the judge saying that they are unable to reach a unanimous decision. Quote, they have exhausted all resources and unable to reach that verdict. Here's part of what the judge told the attorneys today when she read the note.
We're back on the record on 22-117, the Commonwealth versus Karen Reed.
Okay. All right, so counsel, you're aware of our note from the jury. Dear Judge Canoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. Signed by the foreperson. So I want to hear from counsel your view on whether there has been due and thorough deliberation. So let's start with the Commonwealth.
My answer would be no, Your Honor. This simply hasn't been sufficient time yet.
And what does the defense say?
We believe that there has been sufficient.
All right, so I'll hear from both of you in more detail. Mr. Lally, I will hear you.
Your Honor, the jury received this case just earlier this week.
9 weeks of testimony, 74 witnesses, more than 600 exhibits, and the judge, at the end of the day, she said, not enough time. She brought in that jury, 6 men, 6 women, and she told them, we just ordered lunch, take a break, and start over. Judge Ashley, that jury, I was looking at them, and a couple of the women in the back row, they were nodding when the judge said that. The jury foreperson, a younger gentleman in his 30s who always comes up wearing a button-up shirt and tie, he looked defeated today, so there must be a lot of discussion in this courthouse.
Yeah, and you know, the timing worked out, Matt. The fact that she was able to say, go to lunch, take a break, and come back, I think is good that the jury was able to at least have a little breather. Tell us, Matt, what is reaction from the supporters of Karen Reed? I know there are a lot of them there.
Yeah, there's upwards of 100 to 200 supporters. It kind of fluctuates different parts of the day. Everyone wearing pink and holding signs that say "Free Karen Reed." Those supporters are out strong today, getting out there in the traffic and also keeping that buffer zone. But they are optimistic, and here's what a few of them have said today on day 4 of deliberations.
4 days in, listen, for me, it's expected. They had 75, I forget the total, 77 witnesses. To get that all done in a short period of time is a little tough. I think the jurors are taking it serious, and we're going to go with there. But 4 days is a little nerve-wracking out here, though.
I hope the reason they're taking so long is that they're going through every piece of evidence. There was a whole lot of evidence, and I keep in mind that they didn't have the perspective that we have in terms of getting to watch things over again, getting to analyze things. So I'm hoping that they're just really taking their time to carefully go through what they have to go through. So no panicking. I am confident that they will make the right decision.
And those same supporters, I visited with them after that note from the jury saying that they are deadlocked for now. And they say that they are still optimistic. And they actually say that it's a good sign because they know that this jury is taking this very seriously and doing all they can to reach a unanimous decision, which is what they want as well.
Yeah, I would agree with you. I think the jury is absolutely doing that. Now, you've also told us along the way that there are also anti-Karen Read protesters. Where are they at this point?
Yeah, that's something that we started to report today because up till now, we have not seen any anti-Karen Read protesters here. But today, they were walking through the crowd of supporters, almost antagonizing them. They were holding the signs of their own. And we actually spoke to a couple of them. Here was their message for being here today.
We stand for the O'Keefe family. We stand for John O'Keefe. This is an abomination what's happening. They're treating this like it's a recreation, like it's like murder trial. It's a propaganda campaign to get her off. And she launched that FBI investigation and caused reasonable doubt. That should have never happened. How do you feel about the hung jury today? I'm glad it's just not guilty, so we'll see. Hopefully they come to a decision. And you can say with confidence you think 100%. She admitted it.
These Karen Read protesters said that they were only a few of them out here today, and this being their first day that any of us have seen them, the media, because they say that most people that share their view and their opinion are scared to be out here. Judge Ashley.
All right, Matt Johnson, you be safe. We look forward to all your continuing great updates and reporting there live in Dedham, Massachusetts. Now joining me in studio this hour, criminal defense attorney Jeffrey Wolf, and in Palm Beach, Florida, State Attorney Dave Ehrenberg. Thank you both, gentlemen, for being with us today. Jeff, let me start with you. One of the things that stands out to me throughout this trial is I feel like this judge is a little annoyed. And even then when she said note number 3, okay, we have a note. Do you sense any of that? And could that be something a jury picks up on or not?
Yeah, absolutely. I think the demeanor of the judge is extremely important in a trial because the jury, in my experience in trial, views the judge as kind of their de facto parent in the room. It's the person who is going to make sure that they get what they need at the times that they need it, and the person that's going to make sure that they're taken care of at all times. And so when the judge is appearing annoyed with either side of the case or just annoyed with the case in general, the jury's going to take those emotions in and the jury's going to adopt them. And so if the judge is exhibiting that sort of energy, the jury is going to, in my experience, take that energy in as well.
Yeah.
And so I agree with you 100% on that.
Yeah, and it's hard because you know this is 30 days of a trial. Now we're on day 4 of deliberations. That's a long time. Dave Ehrenberg, I wanted to ask you about due and thorough deliberations. This note came out at about 18 hours of deliberating, day 4. Do you agree or disagree that so far deliberations have been due and thorough?
Yes, I'm impressed by this jury. They clearly have taken all the evidence and are doing their jobs. I think in this case that the longer the jury is out, the better it is for the prosecution. That's usually the other way around in most other cases. And that's because if you believe that Proctor was a bad guy and made such offensive texts and law enforcement screwed up, and this is one big conspiracy, then that's it. I mean, you don't need to deliberate any longer than that. But if you think that the evidence shows what I think it shows, that she killed him, then you find her guilty. There's no other middle ground. That's where the defense may have bitten off more than they could chew by not only stressing reasonable doubt, by saying you got to go a step further and show that there was a conspiracy so immense that it's really hard to believe. That's why I think the longer this goes, the more likely a compromise verdict that would prosecute and convict Karen Read on at least something, or a hung jury, which allows the state to do it again. And unfortunately for Karen Read, she's going to have to pay her lawyers again.
Yeah, and you know, the hung jury part, it could be a split verdict in some sense because there are lesser includeds as well for one of the charges, so we have to see what they decide to do. I want to listen together, though, gentlemen, to, again, some of the information that came out through Michael Proctor about the regretful, as he said, texts regarding Karen.
Your assessment, personal assessment, that Karen Read had struck this officer with a car gave you license to call her a
It was my emotions that got in the best of me.
and you called her a whack job. Gave you license to call her that too.
Yes.
Gave you license to say to your friends, oh, no. She's right?
That's what I wrote.
Gave you license to say that she's a
Again, another disgusting comment.
You get to talk about her leaky balloon knot, right?
Objection.
Ugh, Jeff, just horrible on so many fronts. And my question for you is, could that equal reasonable doubt? Could that one witness, in and of himself, knowing all the horrible things he said and did, inappropriate, unprofessional, means he's not credible, could that be enough to say there's reasonable doubt that anything these investigators say at all is at all truthful? We need to find her not guilty.
I mean, it's certainly possible, because what you're talking about is the lead investigator in a murder investigation, and you pull back the veil and you get to see that he's actually just a human being with his own biases, his own emotions, and he actually ends up being the kind of person that these defense lawyers have been screaming from the courthouse steps that he is the entire time.
Yeah.
And those texts show him to be exactly who they says he is.
Yeah.
Exactly who they say he is. Exactly.
Yeah.
They show him as a person who has a grudge against her, who talks badly about her, and who is a pig. And it's exactly who he is.
Yeah, absolutely. I agree with you completely. And what I'd like to ask you, Dave, is about some of those voicemails that Reed left for the victim, O'Keefe, because this paints her in a bad light as well, I would argue. Let's listen together.
John, I'm here with your kids. Nobody knows what the you want her. Yes, 1 in the morning, I'm with your niece and nephew. You pervert. You're a pervert. John, I'm going home. I cannot babysit you. I need to go home. You are using me right now. You're another girl. He's sleeping next to me. You're a loser. So.
And Dave, the one that really got to me was, I'm here with your blank kids, talking about kids. I mean, that's just terrible. How much does this hurt the defense's case?
It does hurt her. I mean, she didn't take the stand, and I think this is the reason why, because I think she is better when she's walking to the courthouse and you have all of her supporters around her and she's smiling. She looks great. But this is who she really is. While her boyfriend was dying in the snow, she's out there cursing him out, calling 50 times, unhinged, drunk. So it's not a good look for her. Now, I actually think this shows that she did not intend to kill him. I mean, if she tried to kill him, why are you going to call him 50 times, leave him a voicemail? I think the case was overcharged with the murder count. I do think, though, this goes to the lesser count of manslaughter. She was drunk. She was angry. She hit him. She knew she hit him. She didn't think she killed him. She didn't think he was going to die. But she knew where he was when she drove back hours later in the snow, was the only one who could find him.
All right, Dave, so you did mention the charges, and I want to take a little bit deeper dive, because we have here the verdict form copies, and they're very short in essence. However, we know the first charge is murder in the second degree. We know that the second charge is manslaughter while operating a motor vehicle under the influence, including lesser included. And then we know the third charge is leaving the scene of an accident resulting in death. Now, 30 days, Jeff, of evidence, of testimony that they have to sort through to say guilty or not guilty of each of these charges. But these verdict forms are pretty simple. Would that help a jury being able to just check off one or the other?
Well, I find that juries have a really hard time differentiating between charges, especially when the verdict forms are so simple. That is where I find that you get the most questions from jurors during deliberations, because they want more information out of those verdict forms than they often get, because verdict forms they're delineated by the law. They say, this is what a verdict form looks like, give it to the jury. And jurors often want more information, more instruction. They're used to more instruction. When you build a piece of furniture, think how big that instruction booklet is. When you build a Lego set with your kids, think how big that instruction booklet is. And this is what we give somebody to decide the next 30 years of somebody's life? Think about that. It's what people expect. They don't get it, so they ask a bunch of questions. This jury hasn't done that. And that might be why they're back there trying to figure this out and so deadlocked, is because they can't agree between these 3 simple pages of paper.
Isn't that interesting insight, perspective? And we were just showing the viewers these verdict forms. Dave, would you agree as a prosecutor, would you agree or disagree? Because we know that the instructions that provide the law are provided to the jury. Does that make a difference with the length and really succinctness of the verdict forms?
I think those are all good points, and it depends on each particular case. I think here it's because the defense gave the jurors a dichotomy, like it's a zero-sum game. Either you believe in the conspiracy or she's guilty. So I think there are part of the jurors who say, yes, the officer planted evidence. It was one big conspiracy. They killed the guy inside the home where there's no evidence he went into the home, and then they dumped his body on the front lawn, which sounds like preposterous. Why would you do that? But okay, and we believe in that. Either you believe in that or she's guilty, and the defense lawyers left no other choice. And that's why I think this is probably going to be a permanently hung jury, because there really is no gray area here. I mean, maybe there's a compromise verdict, but you have some people thinking this is all a plant, this is all a scam by police to set up the wrong person, and the others saying, hey, the evidence shows she hit him. There's no other explanation.
And the nation's literally divided. If you look at the social media that's following this case, half say one and half say the other. You're right. It is either a cover-up, she didn't do it, or she absolutely did it. So that's what this jury has to decide. All right, listen, this jury's been out for 20 hours, but we're also getting to the end of a typical workday. What will the jury do? We'll let you know when we hear any updates. Coming up next, we'll head back to Tennessee for more of the closing arguments in the brother and sister murder trial. Stay with us. We'll be right back.
Tonight on Closing Arguments, a 4th day of deliberations in the case against Karen Reed. We'll dive deeper into what this jury may be wrestling with as we await their decision.
Closing Arguments tonight at 8/7 Central, only on Court TV. Next week on Opening Statements.
We'll tell you what's trending in true crime with an in-depth look at unsolved cases around the country.
Opening Statements with Julie Grant. Mornings at 8/7 Central on Court TV.
to Tennessee for the brother-sister murder trial. Karen and Michael Murray are accused of neglecting their mother, which prosecutors say ultimately resulted in her death. But the defense says the Murray siblings were simply in over their heads when it came to taking care of their ailing mother that they loved. Let's get you back into court now for more of the defense's closing argument.
Now, this was a situation this family was not prepared to handle. They were not prepared to handle what was going to happen with Sheila Murray. They were not equipped for the severity of where this was going to go. They made their decision, based on financial needs, but at some point, as I said in the opening, there was a time when whatever limited ability that this family had, with the limited resources they had, there came a point, a day, a minute, somewhere, where that line was crossed, where they could no longer care for this woman the way she needed. And they didn't even know it. They didn't even know when they crossed that line. Because they're there day in and day out. Those of you that are parents, maybe sometimes you can look at a picture of your child from a few years ago and it's startling to see how much they've grown. Because the day in and day out changes. It's easy to miss as you go along. And that's what's apparent here, is that Sheila's declining little by little. Physically, mentally, she's declining little by little until there came a point where this family wasn't capable of taking care of her anymore, and they didn't even know it until it was too late. And Karen Murray didn't, and Michael really, but both of these children didn't really have any kind of choice in terms of what was going to go on with their mother, in terms of where she was going to go. It's been implied to a degree that Karen had some kind of say-so over the decision to bring her mother home. But I think you've heard from the witness stand, you've heard the evidence, that's not true. That your opinion counted in that house so long as it agreed with Dad's. As long as it agreed with Tony Murray's opinion, that's the only time your opinion really counted, because he had his mind made up about what he was going to do, what he believed was best, and that's what was going to happen. Tony Murray was the one responsible for his wife. I mean, that's speaking of common sense, that's common sense. That's medical facilities, insurance, all that. They're going to want somebody's name to be considered the person that makes decisions about these things. That's Tony Murray, and you haven't been shown anything different. No matter how much we imply that somehow Karen had some say over it, that's not reality. If there was something out there, if there was something that said Karen Murray is the decision maker here, you better believe it would have been put out there on that witness stand. Somebody would have come in and talked about it, but you didn't see that. Because the reality of it, Tony Murray was the decision maker in that home. Sonia, the third child, she told you that she had reservations about this scenario from the beginning. That from the very beginning, she didn't believe that they would have the capability of taking care of their mother. That she, fought with her dad over it. But Dad's word is what went. And it didn't matter what brother and sister think. That Dad, this is what he wants to do. Sonia said she wanted to take her down to Chattanooga with her. And Dad didn't want to do that. He wanted to take care of her at home. But to say that Sonia had no reservations about the ability of her brother, sister, and father to take care of her mother is not correct, because that's not what she testified to. What she testified to is from the beginning she had the reservations, and those reservations remained throughout the time until the end of her mother's life, because she recognized that they were not going to have the ability to handle this. They didn't have the resources or the ability, that she needed a higher level of care. But like her siblings, Sonia's voice wasn't what counted. It was only what her father wanted, was the only decision that was going to be made. And it's not because Tony Murray was malicious. There's not been any proof or any sort of indication that Tony anything but loved his wife and was trying to do right by her. And the proof would show that at the time she came home from Cornerstone, the decision was made to bring her home because that's where she was most comfortable. She was still able to get around, to feed herself to a degree, to walk with a walker. At that time, it seemed like it was okay, that they could make this work, and that she could come home to where she was the most comfortable, where she had spent her life, where she had built this life with her husband, with her children. And her children loved her. All three of her children, Karen and Michael and Sonia, all. I think it's clear. Loved their mother then, love their mother now. And in that house, you grew up, you heard testimony about how much Sonia talked about her mother for all the good things and what a great cook she was and how funny she was. She was strict. And I'm guessing her dad, I'm guessing a Navy man, 26-year police officer, I'm guessing he was probably a little strict too. So in that household, when your parents told you to do something, you did it. You didn't question it, you did it because that's what's instilled in you. That you listen to your parents and you do what they say. And you try to do the best that you can for your family. And that's what Karen was trying to do. Karen Murray was trying to do in this case. She was trying to do the best for her family with what she had, even though she didn't have the knowledge, even though she might have had her own reservations about this situation. Her dad wanted this to happen, and she wanted to do her best to make her dad happy, to abide by what he wanted, and to try to take care of her mother. And that's what she tried to do. And throughout it, she did what her father said that day when the paramedics were there. We did the best we could with what we had. And that's what Karen did throughout the course of events. And for a time, everything was okay. And you see that from the records. Contrary.
We're going to pause the closing argument there, and he's right. There's been no evidence to suggest that the father wasn't responsible for the mother or that these children didn't love her mother. But do you think it was neglect rising to first-degree murder? Stay tuned. When we come back, we'll get you back inside those closing arguments. Welcome back to Court TV. I'm Ashley Wilcott. Thank you so much for joining us this afternoon. A jury has now been deliberating for 20 hours and 18 minutes in the killer cover-up murder trial after telling the judge they were deadlocked. That happened earlier today, right before lunch, and any minute now we expect the jury to be brought back into the courtroom to see if they would like to go home for the day or if they would rather keep deliberating. Of course, Court TV will bring you inside that courtroom as soon as there's any movement. But in the meantime, let me bring in my guest for this hour, criminal defense attorney Jeffrey Wolf, state attorney Dave Ehrenberg. I want to speak to you both about the famous Allen charge, because the reality is all the judge did was say, you need to go further, you need to deliberate more, take a break, have lunch, go back in. What's the difference, Jeffrey, between that and the Allen charge?
So the Allen charge has specific language that appellate courts have found is a necessary factor in letting a jury know what they have to do when going back into the jury room prior to declaring a mistrial. What is required of a jury before they're hopelessly deadlocked and unable to reach a verdict. And so without that language being read to a jury, there is a way to challenge a judge's finding of a mistrial and a judge's finding that a jury is hopelessly deadlocked. And so the language that the judge gave in this case when sending them back in will not withstand that sort of challenge.
And what bothers me, and first I want to mention we may see her father coming into the courtroom. I understand that he has entered that courtroom as an update. Dave, what bothers me is we've actually covered trials here on Court TV, and there's one specific I can think of that the judge never read an Allen charge, that they just gave it in their own language and then said keep deliberating, did it again and said okay, we're going to call it. And I would agree with Jeffrey that that's a problem for appellate purposes if there's a conviction.
Yes, Jeffrey raised a good point. Sometimes you need the exact language just to protect the outcome. But a lot of these cases end up resulting in a hung jury anyways, because, and especially in a case like this where it's a zero-sum game, you gotta, choose sides here. It's going to be hard to split that baby. So, yeah, I guess then the question is, do you have to give the Allen charge? And that's what may come next. The judge may then try one more time. One thing we know from juries, though, is they hate coming back after a weekend, especially when it's a holiday week ahead. So there's every incentive if they're going to come to an agreement to do it now before the end of the day, because if this stretches into next week, I think it's hopeless.
Yeah, and I wonder how long they'll have to go if they stay today, and if they're still hung before the judge says, okay, we can call it, versus nope, you have to come back on Monday. Holiday week next week. That's a big deal, I think, for jurors. I agree with you. Let's see if we can go back in. I understand that the jury was coming in to the courtroom. We don't have a picture yet. So, Jeffrey, as we're talking through this, is it undue, unfair pressure on a jury at 3:30 in the afternoon to say, what do you want to do now? We're not letting you just go home and call it a trial. You have to either keep deliberating or tell us you're ready to go home.
I don't think it's undue unfair pressure. I think it happens all the time in trials. We see it happen, before the lunch hour. We see it happen at 5 o'clock on a Friday. We see it happen on holiday weekends. It's just part of the process. It's the jury system. It's an imperfect system, but it's the best system we've got. And so I wouldn't call it undue, unfair pressure on the jury, but it absolutely is pressure on the jury. There's no question about that. They have been out of work for a very long time. They've got a short week coming up, potentially plans with their family. The courtroom itself probably has some things that needs to get done in those 3 days before it's going to close up shop as well. And so it's pressure on everybody. Well, they need to figure out what's going to happen with this trial. They anticipated probably long deliberations. What they didn't probably anticipate is having to potentially schedule this trial for a second go-around.
Yeah, you're right. You're right. Let's do this. I want to bring any viewers who are just joining us some sound so they can see and hear what the judge actually said to the jury when she sent the jury back to continue deliberations after the jury said we cannot reach an agreement.
Dear Judge Cannoni, I am writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligent consideration of all disputed evidence, we have been unable to reach a unanimous verdict. Signed by the foreperson. We all know how hard you've been working. Lunch will be arriving shortly. When it comes, I'd ask you to clear your heads, have lunch, and begin your deliberations again. So, or continue your deliberations. All right? So I'm sending you back out.
And Dave, number one, is that enough? And number two, what's your experience been when juries do realize, what? We've been deliberating, we've been working hard. We just told you we can't agree. Why do we have to keep talking?
Well, it matters. First, I think that could be enough for an appellate court. I mean, if this ends up in a conviction, could the conviction be overturned because she doesn't use the exact language in the Allen charge? I guess possibly, but I sort of think that is good enough, at least for me. But it does matter that they give it their best, because if this case ends up in a hung jury, the vote will matter to prosecutors. So if this is a 10-2 vote in favor of Karen Read, then prosecutors are much less likely to retry the case. That's why this whole thing matters. If this is 6-6, then they're going to retry this case for sure. But if it's 11-1, 10-2, then it looks like Karen Read would go free after this.
Yeah, interesting point. How much do they take into account? I shouldn't phrase it that way. I know if a case has to be retried, Jeff, that they do take into account the victim's family to speak to them about it. In a case of this magnitude, in terms of the media storm, the number of those against and for Karen Read, how much do you think, if there is a mistrial, the victim's family, John O'Keefe's family, would want to see this retried?
It's hard to get in a victim's family on a case like this, because there's just got to be so much pressure on them on social media and just surrounding this case in the press. All of the requests that have got to be coming through to their house on all of the different issues that surround this case. There's just so much more than just, we think this woman did it. There's so much pressure on them from so many different angles in this case. And all of the time that this trial took, and all of the different things that came out of this trial, and there has to be so much emotion that goes into this, to then have a jury sit there for days and days and days and say they just don't know. They just don't know what happened to this guy. That's got to be so hard on them. It's impossible to know whether they go to the prosecutor and say, walk away, or go get her again.
Right.
It's impossible to know what they do.
Yeah, you make great points, and I know prosecutors listen. They listen to the victim's family. They do take that into account, which is so important. Let's listen, though, because talking about frayed emotions, I think of the judge again. I've mentioned this before. Let's listen when she gets a little ornery with the defendant herself.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Mr. Yannetti, you've seen verdict slips exactly like this, okay?
I actually haven't really.
Have you had no lesser included?
No, we've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option for the
Okay, I disagree with you. All right, excuse me, this is funny, Ms. Reed?
And Dave, talk to me about that. Excuse me, this is funny, Ms. Reed. Does that just happen? What are your thoughts?
The judge just had enough. I mean, Karen Read decided not to testify, as is her right. She has spoken to the cameras outside. There are a lot of protesters who have her back, and they are very loyal to her. And I can see why the judge says, you're playing to, the people in the gallery, the cameras, this is not your courtroom, this is my courtroom. And I think she just had enough. And so I think that's fine. This was not said in front of the jury, so shouldn't impact anything. But it does, I think, take some of the gloss off of Karen Read in a bit, that she's even annoying the judge now, and the judge is not biased. I think she's done a good job in this case.
Yeah, don't smirk at the judge, right? Let's just be honest. No matter how you're feeling as a defendant, you really, really have to keep your emotions to yourself. For this very reason. You never want to annoy the judge. All right, stay with us. Gentlemen, we'll be here. We're going to take a quick break because that jury should be coming in soon. We'll take you to that courtroom. Stay with us.
On the next episode of Accomplice to Murder.
It looked like Virginia and Norman really had a wonderful relationship.
But then greed planted the seeds of a brutal murder.
$1.1 million in benefits to Virginia.
And when she couldn't find a hitman, she decided to use her son, Jason.
She said, no one is going to be getting in the way of me collecting that insurance money, or they'll wind up just like Norm.
Accomplice to Murder with Vanny Politan. All new episode, Sunday night, 8, 7 Central.
Only on Court TV.
Welcome back. The excitement mounts because we are waiting for the jury to come back into court in the Karen Reed case in Dedham, Massachusetts. 20 hours, 20 minutes. And I want you to note that the clock has been paused. I understand that we are waiting for they've just come back on the record. Let's go back in.
Thank you, BC.
All right, so I sent the note in at 3:30 like I've done each day, asking if they want to go home or continue. They indicated that they want to continue until 4:15. So we will continue until 4:15. Madam Court Reporter, Thank you. Okay. All right. So I'll see you at 4:15.
Good. All rise. Court stands recessed.
All right, short and sweet. Let's just recap in case you're just now joining us. Every day around this time, the judge has sent a note to the jury to say, do you want to go home or continue? Well, it's interesting today, the jury gave a specific time frame, 45 minutes from 3:30 to 4:15. We want to continue until 4:15, knowing that it's now 3:43, so that gives them about 30 more minutes to deliberate. Still with us, thankfully, Jeffrey Wolf and Dave Ehrenberg, because help me with this, Dave. I think it's a little unusual when a jury says, we want to keep deliberating for this many minutes versus we'll just keep deliberating and see what happens.
Well, it's a Friday before a holiday week. They want to avoid coming back next week. They're going to give it one last go. I think it's just like the dead cat bounce. It's just we're hopelessly deadlocked, but you know what? Let's give it one last shot. Here it is, everyone. If you don't want to come back next week, let's make this decision now. I suspect at 4:15 they'll still have no decision, and then that's it. The law, though, in Massachusetts apparently is that you got to give them 2 instructions, and then you can't send them back to deliberate unless they, the jurors, agree to do so. So we've got the first instruction. I guess we'll get the second one perhaps today or next week. But the last thing this jury wants is to come back in a holiday week. They want to be on the beach with hot dogs and hamburgers.
All right, to that point, Jeff, if they have to come back Monday, they are going to be released after 20 hours and 20 plus minutes, or 21 or 22 hours of deliberating, going home for a weekend. Although the judge will again say, do not speak to anyone, do not look at anything, don't talk about this case. Does the amount of time they've been deliberating and a frustration potentially that they have to come back Monday of next week when they feel like we've already said we can't reach a verdict, does that increase the risk of any outside influences, even inadvertent influences while they're home?
Well, I think you always run that risk over weekends in the middle of deliberation. I think you always run that risk. And when you have jurors who have repeatedly told you that they do not have a verdict, and so they're in a room, they're frustrated with their fellow jurors, they're trying to figure out how can they convince juror X that they are right and not, juror X is right. And so they go home over the weekend, they're frustrated, they're angry, the judge has told them multiple times that they have to get this figured out. They seemingly see no end in sight to this. July 4th is coming up. You go home, you're sitting at your house, you're trying to figure out how are you going to talk that crazy person who won't agree with you into seeing it your way. You're staring at your computer, you're staring at your phone, you're staring at your spouse. The temptation is there. Let me just talk to this person. Let me just Google this. Let me figure out a way to talk that person onto my side. I think that you're right. 100%, this long weekend is going to be extra long to them.
Yeah.
I really do think it is.
I think it is too. And Dave, do you think that this is one the judge might have said we should sequester the jury for deliberations, which has almost gone the way of the dodo? We don't see that as often as it used to happen.
Yeah, the jury hates it. They're away from their families. Plus, it doesn't necessarily make for a better result. There's going to be a lot more pressure if you sequester the jury just to compromise and get this thing done because they want to go home. I like it when they're not sequestered. You trust the jury not to go to outside sources, and you get the right result no matter how long it takes. But if they were sequestered, in addition to the pressure of facing a holiday week next week, there'd be additional pressure of being sequestered at a hotel, and they would just perhaps come up with something regardless of the evidence. So yeah, I think the judge made the right decision here. Let's keep them deliberating for now, and hopefully this thing will get done.
All right, we're going to see what happens. Now, at the heart of this, defendant Karen Reed, victim John O'Keefe, our own Matt Johnson had opportunity to speak with Karen Reed on different occasions. Let's take a look at that together.
Have you thought about testifying?
I have.
Are you going to give us a hint?
If I had a clue, maybe I would give you a hint. Wait and see how it goes, Matt.
How's it been being in the courtroom for the past couple weeks and everyone's close together, I'm sure?
The intimacy is good. Sunlight is the best disinfectant, and it's vindicating, Matt. It feels vindicating. The truth's got to come out.
Thank you.
It's the only way to do it.
How are you holding up, Karen? Week 6.
Well, Matt, yeah.
Have you given it any more thought? Are we going to get to see you testify? Tell your story?
If I have to, I will. It's up to the big guys.
Stay strong, Karen.
What was that, Karen?
John's DNA was on his clothes.
What are you thinking as you're sitting there during this part of the testimony?
But it's a waste of taxpayer dollars.
Reaction from today, Karen?
Frustrating.
I know you can't say much, Karen, but is there anything that you can say about your relationship?
It was normal.
And you loved him, I'm sure.
I didn't. We were dating. We were dating. There is no case against me.
After 8 weeks.
After 8 weeks, it's smoke and mirrors, and it's going through my private life and trying to contrive a motive that was never there.
Have you thought about what it would be like to be on the witness stand yourself?
Yeah, I have. I'd like to fill in some holes and correct some lies, but it's up to the attorneys, and they'll make the call probably at the 11th hour, and I'm there or not there.
You're lobbying, though, for your chance to testify?
I'm an outspoken person, and I've never not been able to speak up for myself and my defense, except when it matters the most. I've got to rely on them and their expertise, and I'll defer to the attorney.
How do we feel the defense rested?
I feel great, Matt. I feel great.
What a way to end a case, right? With a little truth and professionalism. It feels, you have no idea how good it feels to finally get this thing done.
So did you already do the colloquy? Did you already say you're not going to testify?
Yeah, I won't be. I won't be.
You said that it's hard not to be outspoken, you know?
Very.
And you also mentioned to the media that there are some things that you wish that you could clarify. Is there any?
They'll be clarified one day, Matt. They'll be clarified. It might not be live, but it will be.
One last question. Do you think life can ever be normal again for you?
It'll be different, but it'll be more settled than it is now. It'll never be the same. But it isn't for anybody ever in anyone's life.
Still with us, attorneys Jeffrey Wolf and Dave Ehrenberg. Dave, let me start with you. Do you love to hate her or hate to love her?
I don't like the look of a defendant talking to cameras on the way in the courtroom. If you want to talk, do it on the stand. And for all of our supporters who are saying she's being framed, she's completely innocent, this is a total con job against her, she had the opportunity to take the stand, and she decided not to. And I know that that's something that, as a prosecutor, I can never say in the courtroom because she has a constitutional right not to take the stand. But for someone who loves talking to the media and loves all this sympathy and support, it was an interesting decision for her to say, nah, I'm going to pass on the chance to so-called clear things up.
But I think that's in part why she has so many supporters, because she has been so vocal, Jeff, since the beginning of this defense attorney perspective. Did any of that hurt her?
Well, I'll tell you right now, defense attorney perspective, sit down and shut up. Don't talk to the media.
Yeah,
that is the time that you're going to hear us agree 100%. I will never let my client talk to the media when they are outside the courthouse, and I have had cases where they are. I will walk my client in. I will tell the media no comment myself. I don't like the defense attorneys talking to the media in this case. I know they have a job to do. I know they're doing it extremely well inside that courtroom. But you gotta just resist that urge to talk to the media on your own cases. You gotta let other people do it for you. But I will push back on she had to take the stand and tell her own story in there, because the right to not testify is sacrosanct in our system. And it's not something that we just have to respect when we're doing our roles as attorneys within the system. It's something we have to respect all the time, because you have a right not to testify. You have a right to remain silent in this country. And it is one of the things that separates our criminal justice system from every other criminal justice system in the world. And you are presumed innocent. You do not have to get on the stand to clear things up. You do not have to get on the stand to defend yourself. You do not have to get on the stand to show why the prosecution is or is not framing you. You do not have to testify in this country. She was under no obligation to do so. And the fact that she didn't do it is not something to be ridiculed or mocked on these airways or anywhere.
And I do think, and I know Dave well enough to know he was not at all ridiculing or mocking. I know him to know that. But I will say that I think it's really important to note that it is her choice, not her attorney's, and she chose. That was her choice. That's the constitutional right. Thank you to Jeffrey Wolf and Dave Ehrenberg for joining me today. Michael Ayala joins me next. We're going to bring you more here on Court TV.